All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmera, and I'm the director of the statewide training initiative with Florida Legal Services. I hope all of you are safe, fully recovered, and in good spirits after the recent barrage of hurricanes we have experienced here in Florida. With that said, we are excited to have you join us today for this very timely webinar on navigating the waters of Florida's flood disclosure laws, obligations, and best practices. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of the recording in an email from Zoom within 24 hours. If you don't see that email, no worries. I'm going to drop my email here on the chat. You can just email me just in case. I'll make sure you have access to all the materials and the recordings. The training was approved by the Florida Bar for CLE for 1 general credit and 1 real estate certification credit. I'll announce the CLE code towards the end of the training. I'll also drop it in the chat, and it will also be included in the Zoom email from Zoom. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility, feel free to let me know. The training is being co-hosted by the Public Interest Law section of the Florida Bar. If you're not familiar with PILs, I encourage you to take a look at their website and membership information. I'll drop the link to their website in the chat as well. And final piece of housekeeping announcements are questions and answers. Well, if we do have the Q&A feature, so if you want to ask any questions, drop them on the Q&A feature, and we will address those towards the end of the presentation. You can, in the Q&A feature, you can also ask questions anonymously. If for whatever reason you don't want your question to show up, you can also send it via chat to the speakers, and only we see them. I guess that's the last housekeeping item. So it is my pleasure to introduce our speakers today. They are probably the highest in demand attorneys right now in the state of Florida with all the great work that they do, specifically with disaster-related issues. So I'm going to start with Jason. Jason Susala is the managing attorney of Bay Area Legal Services Disaster Relief Team, a team focused on community engagement, education, and the delivery of legal services to survivors of natural disasters. Jason joined Bay Area Legal in 2009 as a part-time advocate for the centralized telephone intake unit while maintaining a full-time job as a dolphin and sea lion trainer. He has been a full-time attorney at the firm since 2013. Jason began his supervisory role of the disaster relief team in 2018 while it was still a project under the Bay Area Volunteers Lawyer Program, and at that time focused on the development of a dynamic panel of volunteer attorneys specializing on to assist disaster survivors. Now, as a standalone disaster relief team, Jason now focuses on numerous initiatives, including legal aid integration into the regional disaster relief community, innovative partnerships and outreach, and the development of the Florida Disaster Legal Aid Helpline, a year-round statewide hotline for disaster survivors seeking legal assistance. Our other speaker is John Lawless. John is a staff attorney with the disaster relief team. Before joining Bay Area Legal Services, he worked in the private sector, both as general title counsel and as a practitioner in the fields of real estate, estate planning, probate, business, and nonprofit law. During this time in private practice, John also volunteered with Bay Area Legal Services and Gulf Coast Legal Services. He received a bachelor's degree from the University of Florida, an MBA from Stetson University, and a law degree from Stetson University College of Law. So without further ado, I really have to say thanks to both of you for being here today. We know how difficult it is right now, how busy you must be. This is a really important and timely presentation. So without further ado, I'm pleased to pass it over to Jason and John.
Thank you very much. Good morning, or good afternoon, rather, everyone. I apologize. As you may guess, Jason and I are two extremely tired men, but we are grateful in the sense for everybody here giving us the opportunity to dive into this topic, which is both timely and a little bit of a relief, frankly, for us to be able to dig into a media legal issue. So with that said, if Jason, you wouldn't mind advancing to our next slide, we'll start going into our course objectives and what we intend to do with our presentation today. The first thing is, obviously, we're talking about flood disclosures, but flood disclosures exist within the general context of general real estate disclosures. What we're discussing here, of course, are buyer-seller transactions. Obviously, there are commercial transactions that people may encounter, but we're going to focus primarily on residential transactions. So we're talking about people buying generally primary, possibly secondary, but really focus on primary residences. So I want to make sure that everybody has a basic understanding of that. This is going to come in at a more basic level for people who aren't necessarily as familiar with the entire framework, because really the changes to the law that occurred or came into effect October of this year are pretty straightforward. So as we get to that, it's going to be pretty easy to understand what that rule is for anybody who's familiar with it. But I just want to make sure that we get to a point where everybody understands so that we're ready to discuss that. Secondly, I kind of want to discuss, or we want to discuss rather, the issues that we're going to encounter with flooding in real property, not necessarily directly in relation to those disclosures, but generally the issues that are faced by people who own real property and are faced with floods, the information that they are frankly inundated with if they do attempt to do any research on it, and try to help advocates on this call sort of untangle that knot and put clients in a better position to understand the differences in the information they're seeing, what's particularly relevant to them, what's not necessarily as relevant. Then third, we'll finally actually get to flood disclosure law and the state of the flood disclosure law as the end of September versus where we are October 1st, 2024. So there's a significant, but actually fairly straightforward difference there. And then from there, as soon as we cover that, we're going to actually try to discuss the impacts that this new law is practically going to have for home buyers, home sellers, both in the immediate process of the sale and subsequently into potentially years down the line, how that's going to look. So that's what we're going to hopefully accomplish today. With that said, I'll go ahead and move on to our next slide, where we will discuss not flood disclosure specifically, but disclosures generally. All right, there we go. The seminal case and the thing to be aware of for anybody who's not already aware of the state of what the law regarding disclosures in real estate transaction is this case Johnson v. Davis. Say that citation, everybody, because that's actually a really good place to go and look. If you haven't reviewed that case yourself, it's a good rundown of both the state of the law prior to um, the law coming down or the case coming down and how it has basically looked since. Um, the big takeaway in terms of disclosure is that paragraph you'll see there is where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer. The seller is under a duty to disclose them to the buyer. This duty is equally applicable in all forms of real property, new and used. So basically, any residential real estate transaction the seller does have to disclose these issues that are not necessarily readily observable, um, but will affect the value of the property. Now, the case in particular, if you're not familiar with Johnson v. Davis, doesn't have to do with flood specifically. It has to do with actually a leaky roof. The basic facts of the case is there was a transaction. The buyers came in, sort of did their own inspection of the property, their visual inspection. They noticed the window was a little discolored. They asked what that was about. The sellers said, "Oh yeah, we used some special kind of paint when we fix the problem. It's no big deal." They put their deposit down, came back to take a look at it later. Then there was just a waterfall coming out of that window. So there are a few issues that are taking place in the case. What we're really going to concentrate is that paragraph in terms of the change in the law. Um, there's a lot in the case with respect to misrepresentation as well, which is important in real estate transactions generally, but isn't really going to be the focus of this particular discussion. What's important to understand there is the law prior to this was basically that there was no affirmative obligation to disclose these issues. You weren't allowed to lie, of course. You weren't allowed to say that a condition didn't exist that did in fact exist. But if you just shut your mouth and said nothing about it, you were pretty much going to be in the clear. Caveat emptor was just fully in place at that point. So this, you'll see if you read the case, a pretty strong dissent on this change in the law, actually, in that case. Created the affirmative obligation of the seller to disclose those issues to the buyer. And again, that's not just for flood, that's for any condition. Again, this case in particular had to do with the roof, which is a major one, but any condition that would materially affect the value of the property and wouldn't just be incredibly obvious. So, for instance, if you show up to the property and there's no front wall, there are only three walls to it, that's not going to be a disclosure. You don't have to disclose that. That's readily observable. Obviously, that's going to be a problem. You don't have a livable house. So we're talking about these issues, like in this case, where floodwaters came through in a heavy rain, but it wasn't observable in good weather. So the questions that immediately arise in the aftermath of this, when we're getting into flood, is the flood risks A materially affect the value? It seems like the answer probably would be an obvious yes, but a lot of the times we're talking about flood risks, we're talking about things like storm surge. So, multi-million dollar beachfront property. Is the flood risk materially affecting the value? I suppose in a very comprehensive market analysis, yeah, that's built into the price, but also we're talking about valuable property. The other thing is, are those flood risks readily observable? And that can be a complicated question. We'll get into a little bit more detail later on how flood maps, zones work, but that was the question, and still to some degree is going to remain the question with respect to the obligation to disclose a flood risk or in the context of a real estate transaction. Now, flood risk and flood damage are two different things I want to make clear. So if the property has already flooded, got 5 feet of water in, and nobody bothered to repair the studs or rip the drywall out, and it has dried and you can't smell the mold, that might not be readily observable. That's probably a more clear issue. And the law that we're going to get into doesn't strictly address that. So for a lot of it, we are still looking at this Johnson v. Davis standard. What the law is going to address is actual remediation and assistance for in the context of insurance and federal assistance. So we're going to get into the specifics of that again later too. But that, for the most part, is a general overview of the state of disclosure law generally in Florida. And again, I encourage anybody who hasn't reviewed that case, if you are curious and not familiar, just go ahead and give it a read. It's not a particularly long case. It's not one of those really, really weird, dense ones from 1895 that uses a bunch of language that we have to sit there with a thesaurus to get through. It really is good, comprehensive, and informative. Ready for the next slide. All right. So, Jason, do you want to go ahead and take over this, or do you want me to go ahead and grab this one?
Oh, sorry, I started pressing the button and it started going. I was out of control. Whatever. This whole part of handling the slides is quite difficult for me, so apologies. All right, so I'll pick it up here. Thank you everyone for being here today and giving us some of your time. What I'm going to basically do is lay some of the foundation, very basic information about what we're leading up to talking about here with the new law. So, what I'm going to ask everyone here is to abandon the idea that you're not in a flood zone if you live in Florida. Of course, we have understandings of what flood designations are, and we can probably recite those off the top of our heads. But the fact is Florida is a very flood-prone state, regardless of where you are, regardless of what designation you're talking about. If you live here, you're going to be flood-prone, and you're probably in a flood zone, at least practically speaking. Now, when it comes down to actually talking about the flood zone that your property is in, we're talking about the FEMA flood insurance rate maps. The firm designation is really what it is when we're talking about, hey, I'm in zone blah blah blah, whatever. That's going to be the FEMA rate map that we're talking about when we're most commonly addressing what flood zone we're in. So when FEMA's coming up with these numbers, what they're really looking at with the firm designation is the likelihood of a property flooding annually. If you are above 1%, according to what data they're looking at, you're going to be in a special flood hazard area, which is going to be an A or a V, and a V is in Victor, not a B. And again, that's that's a pretty little bar to get over for your threshold in that sense. But I mean, the reality is when we're considering our flood likelihood in general, it's not just a factor of living on the coast, of which we have plenty of in Florida, but inland bodies of water, whether they're lakes, retention ponds, rivers, or streams, or even the factor if you're in a slightly low-lying area where, we have a lot of rain in Florida. So if the ground gets inundated, the ground can't absorb rainfall. Well, that water is going to move somewhere, and it could very well possibly be into your home. So again, going back to the initial notion here, if you're in Florida, practically speaking, you're in a flood zone. So when we're talking about flood zones too, again, there are a number of different data sets that are available out there. We're generally again referring to the firm designation here, but again, we also have county floodplain maps. We have evacuation zones and storm surge maps, but those can all be different. So, for example, personally speaking, I am not in a flood hazard area according to the firm designation, but I am in an evacuation zone C for the county. And as another personal aside regarding Hurricane Milton here, um, our area flooded quite terribly. Our roads were inundated with water for days. Our home did not get flooded, but that water came up about 2/3 up my driveway and prevented us from leaving our powerless property for days following the storm. Of course, no one expected the area to flood that extensively, but again, a local stream was inundated with water. It swelled, it crested. A storm drain pump failed due to power outage, so the storm drains would not drain water. And there are various complications that can exactly be associated with what we experience in Florida generally every day, which is heavy rainfall. So just keep that in mind. We're in flood zones. That's what it is. So, talking a little bit about flood insurance and the National Flood Insurance Program. I'm going to say something very basic here, which most of you likely already understand, but it's very important to make it abundantly clear, especially also for clients you may be seeing out there who are suffering from issues like this. Flood insurance is different from general hazard insurance. So if you have a property, you have a mortgage, you're required to hold homeowners insurance. That homeowner's insurance is going to be your general hazard insurance, and it will cover damage to the property in a variety of ways. But if your property is damaged from rising water, wherever that may be, again, whether it is a retention pond locally that's flooding and water comes into your home, whether your pool overflows, water comes into your home, whether it rains a lot and the ground can't absorb the water and that water moves into your home, that is rising water. And rising water damage is covered by flood insurance exclusively. So again, when we're talking about coverage regarding damage to your homes, it's a very important distinction between general hazard insurance and flood insurance. Now, flood insurance standards and rates, for the most part, are through the FEMA National Flood Insurance Program. Counties and states can opt in to be participants of this, but for the sake of Florida, to my knowledge, all counties participate in the NFIP. And why this is important is because when it comes down to the requirement to actually hold flood insurance, it's not a legal requirement to own a property and have flood insurance. That's not what we're talking about here. What we're talking about is collateral and adjacent services for a property, such as if you want to get a loan on a particular property, maintain a mortgage. If you're in a hazard area, the lender is going to require you to carry flood insurance. So it's an adjacent a service to that property to be able to carry flood insurance. So again, we're not talking about a legal requirement based on ownership. We're talking about a generated requirement because of a contractual obligation associated with a loan, for example. So to be a participant in the NFIP program, counties must adjust their code for construction and mitigation. So their codes must be at least equal to NFIP standards or exceeding that. Many of you have probably heard about the 50% rule regarding construction. We're not going to get into that here because, as my colleague has repeatedly reminded me, um, that's a whole CLE in itself. So we'll just note that the 50% rule is part of NFIP standards, so counties must adopt the 50% rule in order to be eligible to use the NFIP. So we're going to generally talk about FEMA assistance now. So with regard to a property being damaged after a particular disaster incident, FEMA can cover wind damage or flooding damage. It matters not to FEMA regarding how the damage occurred to the property. They will go ahead and provide assistance regardless of how the property sustained damage. That's not relevant whether it's rising water or wind damage for a particular issue like that. Now, when we're talking about FEMA assistance, though, FEMA generally wants to be the last stop for folks seeking a need. If you're insured, they're going to want you to go to your insurance company first and try to get paid out through them to repair your property. For folks who are uninsured or are unable to get appropriate money from their insurance company because they're underinsured, then you proceed to FEMA and they will go ahead and assist in that situation. Now, it's important to note that FEMA has a limit, of course, for how much money they can provide. I think about a decade ago, this dollar amount was set at about $25,000. But it's changed every disaster incident. It's recalculated very slightly based on inflation. So we're up to somewhere around $45,000 now. But again, that number fluctuates based on the particular disaster situation. But again, that's the cap of what FEMA can provide. So there's limitations there for what FEMA can actually do, and that's not going to change. So when it comes down to folks who are in special flood hazard areas, if they are uninsured, they get one bite at the FEMA apple, meaning they can apply for FEMA assistance and receive FEMA assistance. However, again, if they are in that special flood hazard area and had been previously uninsured, FEMA will impose a requirement on that homeowner to carry flood insurance there on out. Now, that relation is only for future FEMA assistance again. So if this property gets flooded in the future after that one-time FEMA assistance, FEMA won't help. So again, it's important that insurance carries on that. And again, that's attached to the property. That must be maintained perpetually in order to potentially seek FEMA assistance down the line. It is of note, though, too, that if folks are in the situation where they had been uninsured and then sought FEMA assistance and were in a special hazard zone, FEMA will work with them for a special rate for 3 years, basically allowing them to carry a policy that is in the amount of basically what the FEMA assistance is rather than the entirety of the property value. So before I hand it over back to John, I'd like to take a minute here to kind of go through some of the flood disclosure laws prior to the implementation of the new section 689 302, excuse me. So let's just take a minute here to go through this. Okay, looks good. It's a joke, by the way. Ain't no flood disclosure laws prior to this. That's all. So John, I hand it back over to you.
That's how you know that it's a really good joke when you have to tell everybody that's a joke. It was my fault. I apologize, everybody. I am gonna, hang on that for just a minute. Don't worry, you don't have to go back, Jason. But it's not as if there were actually no laws with respect to flood disclosure. This statutory requirement in 689-302 is entirely new. And it's actually it's really specific, it's really straightforward. Um, as I had discussed before, the law prior to this with respect to any issue regarding flood disclosure was essentially drawn out of that Johnson v. Davis case that we discussed earlier. So it was whether it was a materially affecting the value of the property and not readily observable. Both of those questions have been open and generally a question of fact in these cases as they've gone forward. So the material effect. My apologies. On the value of the property is one thing. The bigger one generally has been whether or not it's readily observable. As we discussed briefly before, obviously, as Jason mentioned, there are those FEMA flood maps, the firms. And that's what you're familiar with if you're asking what flood zone are you in? You're in A, B, C, X. And a lot of people who are in X, as Jason was saying before, say, I'm not in a flood zone. Well, you are in a flood zone. You're just in a flood zone X, which is less likely to flood than a flood zone A. And a lot of the people, I see a question in the chat, and that's going to be a really good question to get to later. So I'm definitely going to address that one. The Yeah, I've gotten myself all turned around now. See, this is what happens when you get like 3 hours of sleep because you've been on the line a week straight. Um, so we're dealing with Johnson v. Davis as the general standard for disclosure. Whether something is materially observable The argument is that, yeah, you can go ahead and look at your flood zone anytime. You know what the flood maps are public information. You can see whether you're an A, a B, a C, an X. And if you're an X, it's probably low. If you're in a B, it's a little higher. If you're an A, it's definitely high. Your mortgage company is going to let you know that you have an issue because they're not going to lend you money unless you buy the flood insurance. Um, Again, to clarify there too, there is no general requirement for just being in an A that requires you to get flood insurance. There's not a federal standard that says if you live there, you have to get flood insurance or we're taking the property away. It's if you want to get that. It's if you want to get that money to buy the house. They want their collateral protected. FEMA also has its requirements with respect to providing you that. So practically speaking, it's required. Then people tend to think if they're in a B, a C, and X that they're not in a flood zone, which is again not true. Just different levels of risk. Um, One of the other things, practically speaking, too, is you can look at two different flood zones and they may have very different characteristics. For instance, Jason, I know, is in a flood zone X and an evacuation zone C. Where I live, I'm in the exact same position, flood zone X and evacuation zone C. In the recent impact from Helene, we had pretty similar experiences. Milton, however, was very, very different. As Jason mentioned, he lived on an island for about a week. He's just recently been able to get back power and leave his house. I, on the other hand, of course, lost power, but nothing resembling what he experienced in the exact same situation. A FEMA zone X and a flood zone C. Now, part of that might be that he lives in Pinellas County. I live in Hillsborough County. Those evacuation zones are determined on a county by county basis. Um, However, I'm also directly across the street from a flood zone B. I'm like barely on the edge. And I saw not nearly the amount of flooding that Jason did. And, that's an interesting little anecdote, but it also goes to show you, is that a readily observable condition of the property? I don't know. Jason had a lot more risk than I did. Frankly, mine on paper probably looks like it has more of a flood risk. So that's a question that's not particularly well resolved and wasn't particularly well resolved by the state of the law prior to. So what's a good way to actually determine whether or not something is readily observable, and what's a good way to disclose? Let's again a really tricky question. What do you disclose? You just disclose those flood zones. How do you disclose flood risk to a buyer if that's something that you're interested in doing? So the legislature came up with this plan, and as I'm not as recipients of funds from LSC, we're not allowed to lobby, but the state is limited in what it can actually do, and I think this is probably a pretty good solution. We're going to get into a lot of the limitations of what they've done and why they are limited in what they can do, but it's a decent move in I think the right direction. And so you'll see just the language of the statute. The statute is actually very simple, very short. If you haven't taken a look at it, feel free. You're going to see the entire text of the statute in this slide and the next slide, basically. So the seller has to complete a flood disclosure to a purchaser of residential property at or before the time the sales contract is executed. So at the very latest, as you're signing on that line for your not for the actual purchase of the home at the end, you're closing, but at the very beginning, when you sign that contract, you get your inspection periods and everything, you have to be provided a flood disclosure. And that flood disclosure has to include several things. It has to include, first of all, an explanation that a homeowner's insurance policy, that hazard insurance policy that we had discussed earlier, does not cover flood damage. And that's been a tremendous point of confusion from what we have seen, at least in our practice, assisting disaster survivors, is that they just don't have a comprehensive understanding of the fact that, well, I was insured, yeah, but not for flood. And I should mention, by the way, that that's been the case for both homeowners, which is what we're going to be talking about this, but also, just as an aside, so everybody knows, that's also the case for renters. Renters can also purchase separate flood policies. And as we just seen with Helene, with that storm surge coming through, a lot of renters were affected, and they had their required renters insurance from their landlords, but they did not have flood coverage. And a lot of those people do not have an ability to recover through their insurance, which again is a lot more comprehensive generally than the recovery that they can get from FEMA, because FEMA has those caps. FEMA is available to those survivors, both owners and renters, to provide them with some relief because they're either underinsured or uninsured. We can get into that whole distinction to a larger degree if anybody is interested later on in this. But for right now, I'll go ahead and, and try to keep it fairly brief. Um, but that's the basic overview there, is that just keep in mind that this is meant to disclose to homeowners that there is that distinction. And we as attorneys a lot of the time understand that, but sometimes it's so obvious to us, we forget that our clients don't. So that's a big deal. The other thing that it does is it requires the seller to disclose whether or not they have filed an insurance claim for flood damage. So rather than sit there and evaluate whether, well, is it an A or is it a B or is it a C? How much of a risk is that? At what point do you have to disclose? What point does it materially affect the value? Just say, did you file an insurance claim or not? Did this property actually flood while you had insurance? And it's basically just a yes or no. And the next slide, we're actually going to get to the content of this disclosure. And then the next one is whether or not they've received federal assistance for flood damage, which would be if they were uninsured, if they were underinsured, if they called. FEMA is probably the biggest the biggest one to keep in mind. Just as another aside, and again, this is probably the topic from another CLE, is the Small Business Administration provides a lot of relief to homeowners in the aftermath of a disaster. Well, huge point of confusion about that, by the way, as well as the Small Business Administration. I don't own a business. I'm not part of a business. Why should I be able to get that relief? I've heard that conversation taking place, at the DRCs, just on the phone, as I'm talking to people that I know in the aftermath of this. You don't have to be a business owner. You don't have to be associated with a business to receive that SBA assistance. So just throwing that out there, SBA assistance is one of those things that would be a federal assistance for flood damage. Yeah, I'm going to shut up about that for right now because that'll just take me off on a complete tangent. So with that said, let's go ahead and move on to the actual contents of the disclosure. This is it. This is the actual language in the statute that is specified for the flood disclosure form. So as we're beginning to talk about, part of it was best practices. Here's your disclosure. If you're in a situation to be either reviewing a disclosure or drafting a disclosure, the work is done for you. If you read that statute, the one line that I did leave out in the prior slide was that the flood disclosure will be in the following form. Not substantially in the following form. It doesn't give you wiggle room. It says it shall be in the following form and then lists this. This is the disclosure. So you'll see at the beginning there's that specific explanation that homeowners insurance policies don't cover the flood damage. And then let them know to discuss with other people the need to purchase that separate flood insurance. Obviously, need is kind of a strong word. But and a lot of the times you're finding it a good idea. Again, going back to Jason's island that he was living on, he and I think most of the people in his neighborhood are not in flood zone A. They're not going to be required by their mortgage company to purchase flood insurance, and that's really the only requirement that a lot of people bump into. Which is, hey, does my insurance company say? Does my mortgage company say that I have to? No. Well, then I guess it's just not a thing. No, that's just their willingness to take the risk in lending you the money. That's just their willingness to. It's a business decision. It has nothing to do with your actual. Well, it only has to do with your risk to the extent that they're willing to take the risk as a business decision. So a lot of Bs that were not required to get flood insurance, nevertheless flooded in that neighborhood. Jason almost flooded in a C. Fortunately for Jason, he did purchase flood insurance. I'm giving all your personal information out. I apologize, Jason. But that's a reason that it might be a good idea to purchase flood insurance outside of a flood zone A or a flood zone V, depending on the case. The second one is whether or not, again, specifically, the seller has received federal assistance for flood damage to the property, including but not limited to the FEMA assistance. Like I was saying, the SBA stuff would count for that too. And these are just simple checkbox, yes or no. If they have filed a claim with their insurance provider, it's probably actually flooded. If they've received federal assistance for flood damage, it probably has actually flooded. So a good way to assess the flood risk for a buyer is whether or not it has in fact flooded while the prior owner had the property. You'll notice that this only extends to the prior owner's experience. So if the prior owner purchased the property from somebody who had experienced flood, and then they never did, they're going to be no's on these checkboxes. So it's not going to be comprehensive, but also to that extent, it's not clear enough as to whether or not those sellers would have even been aware, because this disclosure is less than a month old. It's the 16th, so it's this is the 16th day of its existence as a law. Um, and then it goes on to disclose what flooding means. And the reason that this is important is some of those distinctions I think we've touched on briefly between what hazard covers and what flood covers. Is there's the overflow of inland and tidal waters, which is just, rising lakes, rising rivers. Storm surge is the next one. The unusual and rapid accumulation or runoff of surface waters in any established water source, river, stream, drainage ditch. So that's going to cover all that stuff. So you're going to get storm surge, rising waters, and then just rain inundation, which is, by the way, how you most often see floods happen in what are called those flood zone X properties. A lot of the times people, again, say, I'm in flood zone X, I'm not in a flood zone. Again, not true. You are in a flood zone, you're in flood zone X. One of the most common ways, by the way, just as an aside, that those properties flood is if they have a pool. And so, yeah, you're in flood zone X. You could be, 100 feet above sea level. Storm surge isn't going to touch you. You're not going to have to worry about that. Plenty of runoff. But if you've got a paved surface that is curving down toward your house and it just rains a whole bunch, that's going to come into your probably sliding glass doors is what you're going to have coming out there. That is a flood. There is a flood risk there. And if you don't have flood insurance, you're not going to be covered for something like that. So that's why it's one of the things that's important to keep in mind, that if you're dealing with a property that didn't have that flood insurance but did have a flood risk, they didn't get a claim with a flood insurance company because they didn't have flood insurance, and they may not necessarily have sought federal assistance, because if you're just talking about a heavy rain, FEMA assistance is only going to come into play with something like a major disaster like Milton, Helene, Debbie. Um, Long summer storms, the real heavy downpours that we get routinely in the state of Florida, generally aren't going to activate a FEMA response. And so if there's no FEMA response, there's no FEMA assistance. Your property might still flood, and if you don't have flood insurance, that's all going to be missed. Now I think I see some questions coming up, and again, we'll go ahead and go through the questions more thoroughly when we get to the Q&A session. But generally, if the problem has been fixed and it doesn't fall into these categories, does it have to be disclosed? Johnson v. Davis. Facts and circumstances. Great question. I unfortunately don't have a great answer for you. But that's the basics on the actual form of the flood disclosure. So again, if you are representing a buyer, you should see this language precisely. If you are representing a seller, give them this language specifically. Like I said, that statute does not say in substantially the following form. It says in the following form. All right, ready for the next slide. Now we're going to start to get into a little bit more of the trouble that we see. And this issue that I'm bringing up here on this slide, I think is actually the reason that we specifically were asked to start discussing this issue. I'm not going to read word for word through this. We are going to provide these slides to you, so don't worry about having to furiously copy this down, but I do have the citations there for you. When you're dealing with FEMA disaster assistance, these are the insurance requirements. So basically what you're going to see is if you've got somebody that's gotten flood damage on their property, that they're going to be required going forward to maintain flood insurance on that property, just like Jason was saying. They'll give you that assistance for 3 years, but they have to maintain that insurance at least at the level that they received assistance. They're, of course, not going to be a problem if you want to get more flood insurance, but it has to be at a very minimum that amount. Now, the really interesting part comes in the second area here at the bottom, is if it's a homeowner, the coverage must be maintained, again, as long as there's a residential building at that address. Then I have that last part. The flood insurance requirement is reassigned to any subsequent owner for the flood damaged address. Now, if we could scoot back to the actual disclosure, you'll see the seller has or has not received, under number 2, federal assistance. Now, if the owner 2 owners ago received flood insurance, the answer to question 2 is going to be a no. And again, this disclosure is 16 days old, so they may never have found that your current seller may never even know that FEMA assistance was given. But as you saw from our rules in this next slide, slide 10, that condition follows the property address, doesn't follow the owner. So even if it was never disclosed, possibly because the current owner isn't aware, or possibly because even if they were aware, they're not required to disclose under the specific conditions of this disclosure, you're going to miss that. And then if you are underinsured, and not for the amount, say, that the prior assistance was given, you might be out of luck permanently. Um, as long as this particular property maintains that address at least, which is an interesting question. Now, how do you find out whether or not a property independently was affected by a flood and received FEMA disaster assistance? Well, there's nothing that goes into public record. There's no requirement that they file a lien or a notice in public record for somebody to search in official records the condition of that property. You can try to ask FEMA. Maybe they'll give you an answer. Maybe they won't. Um, Obviously, there's always FOIA. You can try FOIA, but when you're dealing with the timing of a real estate transaction, there's no guarantee that you're really going to get a solid answer to this question. So, how do you practically protect yourself in a situation like this? There's still a gap there. Now, how the state of Florida could address that statutorily, they can't tell FEMA what to do. They can't tell FEMA that they're required to make this recording. It's also very difficult for them, practically speaking, to put into place a requirement to disclose information that they may not have. So, again, I really shouldn't get into the specifics of it, but I mean, I think they're doing the best that they can with this, but it still leaves a significant gap. So that's really one of the bigger issues that we had identified just in disaster relief generally is this requirement to purchase home insurance follows the property address. It's reassigned to the subsequent owner without necessarily giving notice to the subsequent owner and without being recorded in public record to give constructive notice to the subsequent owner. So interesting little piece there. I think I'm ready to move on to our next though. All right, and some of the other practical limitations here. So you've got your failure to disclose prior to the sale. Again, it just kind of takes us back to Johnson v. Davis. You can sue for rescission, you can sue for your damages. If there are any costs there. If there are any misrepresentation, which you'll also see in Johnson v. Davis, you can deal with that as well. That's really nothing new. And then the next part that's not really nothing new either is failure to disclose is discovered subsequent to the sale. Same damages, really. Rescission damages, sure. The problem is how long after the sale is this discovered? If this is discovered 3 days after the sale, a heavy rain comes down or something and floods, you have a decent chance, practically speaking, of both getting your sale unwound or seeking damages that may actually be recoverable. But I mean, the practical consideration is, let's face it, that these properties probably aren't flooding every week, every month, every year. It could be every 5 years you get a flood. So what's going to happen to somebody who doesn't get who has an actual fraudulent disclosure? Because they are required to give this disclosure, and if they say no and they knew better, it is fraud. Or you're dealing with somebody who's there's an owner between the flood incident and your current owner. So again, they got a flood disclosure that says the prior owner never applied for insurance proceeds, never applied for FEMA assistance. There is no fraud there. There's no misrepresentation. They didn't do it, but the people they bought it from absolutely did. This doesn't cover that gap. And what are you going to do when you go back, 3, 5 years after a sale, and you try to find the person who sold you the house and sue them for what damages? Unwind the sale 5 years later. That's going to be a difficult haul, and practically speaking, in court. And damages, yeah, sure, you might be able to get a monetary judgment against somebody. What they have done, meanwhile, though, potentially, is take the money that they bought, they received from you, put it into another homestead property, um, and that's now protected. They might be retired. Their only income might be Social Security. They might be judgment proof. So practically speaking, where are you sitting? Hopefully you're insured so that you can go to that pocket and deal with it. But that really doesn't solve the other issue because that solution was in place before this disclosures. So there are significant gaps in what this can do. So in terms of best practices, really the best thing to do is ask those questions specifically, and as usual, make sure a thorough inspection is done, and make sure, particularly when you're dealing with these real estate contracts, a lot of the times the sellers will try to get you to waive or shorten the inspection period. Make sure that your buyers have an adequate amount of time to do that inspection, because that's really where you're going to catch this more so than with this disclosure. So that again said, the disclosure, good idea, helpful, might be able to help catch some issues. But again, practically speaking, even if they outright lie to you, um, this is not the sort of condition of a property that's necessarily going to come to light in the immediate aftermath. Like I said, when Johnson v. Davis, it was heavy rain. You see that all the time. It's not going to take you that long to figure it out. You might not become aware of a flood risk until 3, 5, 10 years later. And then what? But that's really the extent of that. I don't have any good answers to that. Those are just the open questions that we have continued to deal with. It is now 12:45, and we have a 55-minute presentation. So I will shut up for a moment, get to our question slide, and see what we have in the chat.
All right, so we had a few questions in the chat. I believe they were answered, but for the benefit of the audience, I'm gonna read them out loud, and we can probably just provide the answer again. The first question was, does FEMA require flood insurance on a property if provided assistance to even if ownership transfers? Is the new owner required to maintain flood coverage?
And so
You want to repeat
so
the answer?
just to clarify, the answer is absolutely yes. Is anybody making them aware of that? Maybe, maybe not. The rule is written in such a way that it transfers, again, not necessarily with any notice to the subsequent owner, but it follows the address of the property. So that insurance requirement is maintained, not necessarily with notice to the person who has that requirement. So I am sure everyone can extrapolate from there some of the issues that arise, and some of the questions that we've kind of been asking in terms of systemic legal issues as well. But yeah, excellent question. And that is precisely one of the problems that we see.
And the next question, which was also dropped in the chat, and I believe it was answered. It's a great question too. What if you have flooding but do not file a claim? Do you still need to disclose? And this is referring to the new statute that requires fire insurance claims.
Mm-hmm. And I mean, because the answer, practically speaking, is no. You don't necessarily have to disclose. You definitely don't have to disclose that you made a flood claim because you didn't. Do you have to disclose the damage? Is a great open question. Now, if, for instance, the flood happened, you did not adequately repair the damage, and there is a condition remaining in the property, that's going to, an actual physical condition of the property that's actually affecting it structurally, you do have a legal obligation to disclose under Johnson v. Davis. But if you remediate that claim and never make the flood insurance claim, do you have an obligation to disclose? Well, certainly not under the new statute. Does that materially affect the value of the property, and is it readily observable? Well, again, we go right back to Johnson v. Davis and whether or not those questions are answered in the affirmative. So the answer is probably not in a lot of circumstances if you're able to properly remediate, because those flood areas are readily observable. Again, because it's public information. But as long as there's no actual structural damage, there's not something there to materially affect that, you're probably not going to disclose. And we might see people going forward making that choice, particularly investors. So excellent, excellent open question. That's the best I can answer it. You're kind of in the same boat as I am. The person asking that question it's an interesting one. We'll see what comes of it, because again, this disclosure requirement is new. Specifically under that disclosure requirement, the answer's obviously no, not with this, and then we just get stuck back to Johnson v. Davis.
And John, you mentioned earlier this law is only 16 days old. So
Yes.
amazing presentation, by the way. Like putting something together in a 16-day-old law is not an easy task. So I just wanted to kind of plug in the disaster umbrella group and even the housing umbrella group. If these type of situations or questions come up, after this training, obviously that were not addressed here, can you maybe talk a little bit about these umbrella groups and how the civil legal aid community can benefit from them?
Sure. Rather than talking over you constantly, Jason, do you want me to give you a chance to give that, or do you want me to do this too?
No, you're good, John. I'm just enjoying. Thank you.
Oh, I really thought you were going to do it. All right. So yeah, we have a couple of Jason, you're more involved in the HUG and the housing utility group. So I'll go ahead and let you speak on that. But a lot of the programs in the state of Florida are also involved in what's called the disaster umbrella group. And that's spearheaded by Legal Services in North Florida, and Kathy Grunwald from Legal Services in North Florida really keeps that one going. But it's a really useful place for us to get together, particularly our disaster programs, but other programs that are dealing with disasters, even if you don't necessarily have a specific disaster program. It's a great place for us to come together and discuss some of the issues that we do see as we're responding to these issues. Because even though we're becoming unfortunately more and more familiar with disaster response and what needs to be done, one important thing is the FEMA rules all changed for the first time in 20 years in March of this year. And that's been kind of an interesting challenge because what they haven't done in response to that is actually update their policies and procedures guide to match the change in their rules. So I know even again, Kathy up in Tallahassee ran into that issue almost immediately after they had those tornadoes in April, with different rules being applied, them being applied inconsistently, or just FEMA staff not having a good set of guidance as to what they're supposed to do in these specific situations. So that's a good place to come together, discuss those issues, and prepare as a group to have a more unified approach. Again, that's just one specific example of what the disaster utility or disaster. I keep saying disaster utility group, the disaster umbrella group can do. And I think we're going to see a lot more of that since we've had a nearly unprecedented event. We certainly haven't seen a season like this since 2004 at the very least, and certainly not two major hurricanes this close together as we saw with Helene and Milton. So a lot of new questions are going to come up. So again, yeah, the disaster umbrella group is a great group to join, and we'll be able to distribute the information on how you get involved in that as well. Jason, I'll let you talk about the housing utility group umbrella group.
Umbrella. Umbrella. Think about rain, John. Again, we're dealing with disasters. It's a theme, right? Hold you out your umbrella. It's great. Uh, yeah, so HUG has been very I joined HUG many years ago, quite honestly, when I was working for the senior advocacy unit Bay Area. And there's just a wealth of housing information here for Florida advocates and HUG. It's been a little bit more quiet lately regarding posts of their email distributions, but I found it to be an extremely valuable group just in general for housing issues and things. So again, for those of you who practice in disaster relief areas, one of the primary issues that we're encountering are housing issues, whether it be home ownership issues or landlord tenant issues and things like that. And HUG, really envelops all of those things about very primary concerns going on in the state, things that folks are seeing, and it's a great area to sort of share your ideas and get information from other advocates who are practicing in it. So, yeah, it's another great resource. And again, for all these, it's very helpful to sort of connect with these groups in general because again, there are a lot of folks in the state who are doing a lot of great things. You may not know about it, but again, connecting with these will connect you with them to really help our advocacy statewide. And again, back to like the disaster umbrella group too. The whole idea is all the programs throughout the state, all the legal aid programs throughout the state are working on better collaboration, better communication with regard to disaster response, to have a statewide framework in response to some of these incidents. And right now, this is a perfect opportunity for us to be very involved because, again, just as John has said, we have not seen a disaster hurricane season like this for a long time. These are catastrophic storms. Our state has really suffered significantly, and our at-risk communities are really in peril regarding recovery and everything. So For us disaster relief folks, this is it's imperative to connect with statewide members to make sure that we're reaching the populations that really need us most.
We had another question in the chat, which is whether this recording can be shared with other people. Absolutely. This is part of the purpose that we had before with this training. I met Jason and John last March. It felt like it was years ago, but it was last March during the disaster training conference, right? So, and this topic came up, and this is where the whole idea of let's do a training like this one to create awareness. So feel free to share this webinar with other advocates as well, other resources. The idea is like if we have this new law, it's not going to have a lot of impact if people don't know about it. So right now, in particular, when people are applying for FEMA benefits, if if they experience flood, and this could come into play not only short term but long term as well. And I did want to like throw out another question as well because we did cover the new law and how it covers real estate transactions. So what about the rest? What about the mobile home owners or the people that are considering buying a mobile home and renting a lot, or people that are renters that are looking to rent a house or an apartment that may have been flooded? Any tips, or what would you advocate for? What would you advise those people?
Now, with respect to mobile homeowners, it can be a little tricky. Sometimes it does look exactly like a real estate transaction, in which case that flood disclosure is going to be placed. But if you're looking at a lot of the disclosures that may be for the sale of the mobile home itself, but not necessarily the underlying land, that this disclosure scheme isn't really going to apply. And it actually ends up being an entirely different area of law because we're talking about it's essentially the sale of a car. And that, by the way, another topic for a CLE, we're probably going to see a lot of things like cars that have been flooded out in Helene and Milton start to come onto the used market. The mobile homes are more or less going to be in that same position. And there really is not a good scheme for disclosure in that respect. So you get your Carfax, things like that, but that's not really available for mobile homes. So that's a very big gap. As far as renters go, the same thing really applies. There's no such obligation for renters to have the condition disclosed in that sense. So if there is a major flood risk, but the damage has been repaired, there's not going to be any obligation there too. So this disclosure is really limited to protecting home buyers. So what to do is really the only thing that you can do is evaluate what has happened in past incidents. Luckily, I guess for a lot of renters, particularly in the area that Jason and I are in, the Tampa Bay area and just south of us, well, really and north of us, the whole center of the state has gotten a pretty good idea of it this year of where those flood risks are because that historical data is available for people to review. Trying to get practically renters, particularly renters that are qualifying for our services, to take the time to do that is going to be a difficult haul. Getting people to talk to us before they engage in these is going to be difficult, but really what they should be doing is, if they can, is reviewing that historical data if they're not in the situation where this flood disclosure is going to apply.
All right, and one final plug for Bay Area. While I drop some information here in the chat, can you talk a little bit about the disaster legal helpline? And I don't have the number right here with me, but if you want to mention a little bit about it before we wrap up.
Yeah, absolutely, Jorge. Thank you. So again, it's kind of part of the statewide framework of disaster relief amongst the programs in the state. Bay Area operates the Florida Disaster Legal Aid Helpline. That is a helpline where folks can reach out from anywhere in the state to apply for legal aid services. Folks calling in from our direct service area, which would be Pasco, Pinellas, Hillsborough, Manatee, and Sarasota. We can directly assist with extended services for their disaster-related legal needs. Folks calling in from other areas throughout the state, we have a whole referral matrix in which we can bring people in, do intake, do the brief service, and then get them to their local legal aid provider for extended services if they need that. So it's a one number system, basically just they can be distributed everywhere so that folks can call in to seek assistance with their disaster related legal needs. And that number is 833-514-2940.
All right, so I don't see any other questions in the chat. Again, Jason and John, I really have to thank you for this amazing and really timely presentation. I want to thank everybody that registered and attended today's webinar. I know it's not an easy time to take some time to do webinars for all the work that that you're having to do right now with the disaster. We hope you have found this session valuable and that we provided useful takeaways for your work. I did drop the code here, the CLE code. I will email everything to everybody that registered, including the link to the recording, which again, you can share with anybody that you would like to. It will also be posted on YouTube for the people that didn't register. You can find the recording on YouTube and share it with everybody. And yes, what the materials, the slides, I'm gonna make sure to include those in the email as well. And they will also be in the description box in the YouTube post. So thank you, Jason and John. If you're attending the consumer conference next week, you might run into John and you might be able to say thank you in person. You will also run into me, even though you don't need to thank me. You can meet people like John. So maybe if you're attending, hopefully we can see you there. Pro Bono Week is next week. So this providing this link to this recording is kind of a great gift to pro bono attorneys out there. We also have a pro bono matters training, by the way. And yeah, I think that will be all. We see a lot of thank yous in the chat here for both Jason and John. So thank you again for this amazing presentation and have a great rest of your day.
Thank you, Jorge, and thank you everyone for being
Very
here
much.
and giving us a bit of your time on your certainly busy day. And take care, everyone.